Well, thank you. Thank you everyone for being here. I'm Melina Fernandez. I'm chair of the Membership and Outreach Committee of the WFM. I will be your host today and your moderator. We are here today with Mark Oettinger and David Gallup. These are two very special people that are willing to and be happy here to give their time and speak to us a little bit. Just a little bit about this meeting. This is a meeting hosted by the Membership Outreach Committee. It's about our goal about retention and community building. To fulfill these objectives, we are trying to organize meeting to strengthen our global community and talk about important perspectives such as global issues and different topics. So this will be a nice discussion. And we will have a Q&A session at the end of it. It will be about 5 to 15 minutes. So please, if anyone has any question, please put it on the chat or just wait until the end of the presentations. Now, I will present Mark. He's a Burlington, Vermont-based trial and international lawyer. He chairs the Worker of Human Rights Development Project. Mark was admitted to the practice of law in 1980 and has taught as an adjunct professor at Vermont Law School and Champlain College. He has published extensively in fields of transnational law, human rights, and international judicial systems. He was a senior Fulbright scholar, and Mark grew up on 4 continents. He's a dual U.S.-Swiss citizen. He's an active national ski patroller and a competitive duplicate bridge player. So thank you, Mark, for being here. You want to say some words before starting, and then I will introduce David.
Just thank you for the invitation and welcome everyone, and back to you.
Thank you. Now I will introduce David Gallup. He specializes in human rights, world citizenship, and world law education. He's president and general counsel of the World Service Authority in Washington, D.C., a global public service human rights organization founded in 1954. He's also a board member of Citizens for Global Solutions, creator of the student-run World Citizen Club initiative, and convener of the World Card of Human Rights Coalition. David has been interviewed by media such as BBC, The New York Times, and Foreign Policy. He was interviewed for A Beautiful Mind by biographer Sylvia Nasar and for Cosmopolitis, The Committee of the Global Citizen by Atosa Araxia Braham, senior editor at The Nation. David also received a Day from the Washington College of Law, American University in Washington, D.C., in history, an AB in French and AB in history from Washington University in St. Louis. So thank you, David, also for being here. Please, if you want to say something about yourself.
Sure. Well, I'd just like to say thank you to the World Federalist Movement, IGP, for hosting us today, and the World Court of Human Rights Coalition. I'm delighted to be here to tell you more about the history behind the idea of a World Court of Human Rights, and to hear also from Mark about the draft statute, one of the draft statutes, and we'll talk about there are actually 2 draft statutes. So I'm delighted to speak with everyone today.
Well, thank you for everyone who recently joined in. We are going to have a presentation from Mark and David, and there will be a session about a QA from 5 to 15 minutes. If you want, you can send your questions or your thoughts about the chat, and we will review it at the end of the presentation. So please, David, I think that you will be a start. So the floor is yours.
Yes, thank you so much. Yeah, well, welcome everybody to today's webinar about the establishment of a future World Court of Human Rights. It's the necessity and feasibility of such a court. As Melina mentioned, I'm David Gallup, president of World Service Authority, which is a human rights organization founded by world citizen Gary Davis in 1954. I'm a human rights lawyer and convener of the World Court of Human Rights Coalition. So today's webinar will provide a brief historical overview of the concept of a World Court of Human Rights, an elaboration of previous and current discussions about the need for such a court, And hopefully at the end, we'll have a few minutes for questions of open dialogue about the benefits and potential drawbacks of such a court and the future of the court. So after my introductory comments, attorney Mark Oettinger, who is the World Court of Human Rights Design Team Coordinator and the chair of the World Court of Human Rights Development Project, will provide a rundown on the substantive and procedural aspects of the Lucknow Treaty, which is one of the two treaties that exist, or draft statute treaties for a World Court of Human Rights. Mark, for many years, has helped us to redraft the statute. We have a little statute booklet here. It's about 50 pages, which also provides some history behind it. If anyone wants a copy, please. We'll put my email in the chat, but we also have this available on our website, worldcourtofhumanrights.net. So he helped us redesign and redraft that statute from a previous statute, which I'll talk about here momentarily. And he is currently chairing the development project, and he'll tell you more about that. So after this discussion, we'll, like I said, open the floor for further questions. So I'll start by noting why this topic is important for consideration by lawyers, law students, civil society, focused on public international law, human and environmental rights, and global justice. Then I'd like to mention why the creation of a World Court of Human Rights is important to me as a human rights, world citizenship, and World Federation advocate and activist. So first, I'll mention why the creation of a World Court of Human Rights is important for the advancement of and adherence to human rights generally. Currently, no global tribunal exists to handle claims of human rights violations. And I stress the word global because there's nothing at the world level to handle human rights violations in a tribunal. So neither the International Court of Justice nor the International Criminal Court provide adjudication for redressing human rights violations of individuals. The three regional human rights courts, the African Court on Human and People's Rights, the European Court of Human Rights, and the Inter-American Court of Human Rights, only claim jurisdiction for rights violations within those regions, and only for countries that have ratified the accompanying regional conventions. So a World Court of Human Rights can be an important factor in uniting human rights principles and practice in the global judicial architecture, in addition to the ICJ and the ICC and the three regional human rights commissions and courts. We envision a World Court of Human Rights as an independent and authoritative tribunal focused on fundamental justice, particularly for grievances that transcend national boundaries, where local recourse fails, and where no regional human rights system exists, such as in Asia. And Asia has 60% of the world's population. And if your rights are violated, like you're a member of the Rohingya group of people living in Myanmar, and your villages are being burned, and then you have to flee to Bangladesh, you're stateless. You can't even get your rights respected in Myanmar. And when you get to Bangladesh, you're there as a refugee in a camp. You can't get your rights respected there. There's no regional system that you can go to. This is why having a court beyond the regions at the global level is so important. There's a growing coalition for the creation of a World Court of Human Rights, which attendees in today's webinar can join as individuals and or as representatives of organizations. Law students, individual attorneys, as well as human rights and civil society organizations can play a large role in advancing the coalition and in providing input in the court's development. And for more information about the coalition in court and to express your support for the court, either as an individual or as part of an organization, please consider visiting the website, which is worldcourtofhumanrights.net. And I can put some of these links that I might mention here in the chat later on. So worldcourtofhumanrights.net. As a venue for adjudication of violations of human rights occurring around the world, a World Court of Human Rights could provide an educational onboarding point for practicing legal professionals interested in the protection of human rights, as well as whose clients have been affected by rights violations. This discussion will be of interest to current students in human rights clinics, professors, advocates, academics, and civil society activists who are focused on the future of public international law and the advancement of human rights globally, and especially in the world we're living in now, where democratic principles and the rule of law are being challenged and are eroding. One of the main reasons to consider the creation of a World Court of Human Rights is the increasing violence and wars that are occurring around the world born out of oppression and human rights violations. By focusing on respect for human rights at all levels of government and human interaction, we may be able to reduce or even prevent conflicts before they start. Furthermore, by providing a judicial venue for individuals and groups in vulnerable situations such as indigenous communities, stateless persons, refugees, persons facing racial, ethnic, gender, and other discrimination, the court could have an important role in exposing the persecution that many people face on a day-to-day basis. So now let's take a brief historical view of the idea of establishing a World Court of Human Rights. Back in 1948, the government of Australia proposed the creation of an international court of human rights through the UN Human Rights Commission of the Economic and Social Council. The draft contained 32 articles, approximately half of the number of articles in the statute of the International Court of Justice, on which that draft was partly modeled. The UN decided to focus instead on the Universal Declaration of Human Rights, and I also have copies of the Universal Declaration of Human Rights in multiple languages. So if anyone wants a copy of the handy pocket-sized copy, please let me know. So the world sort of focused, or the UN focused on the Universal Declaration of Human Rights and on the development of the two international covenants, the Covenant on Civil and Political Rights, the Covenant on Economic, Social, and Cultural Rights, rather than on the establishment of a human rights court. So the Australian proposal did not move forward. In 1974, Gary Davis, a peace activist well known as World Citizen #1, who had given up his US citizenship after having been a bomber pilot in World War II, had drafted another version of a World Court of Human Rights, which that version included a long list of human rights that the court would recognize and adjudicate. And you can learn more about Gary Davis's story by visiting the website theworldismycountry.com. That's theworldismycountry.com. But we'll get back to that this momentarily. So fast forward to 2009, 2010, human rights experts Manfred Nowak, Martin Scheinin, and Julia Kozma were tasked by the Swiss Foreign Ministry to prepare a draft statute for a World Court of Human Rights, which is called the Consolidated Draft Statute and contains 54 articles. So please consider taking a look at the Consolidated World Court of Human Rights Statute on the website of the European University Institute. And I'll put that very long link for that draft statute in the chat, although you can just do a search online with the phrase Kozma, K-O-Z-M-A, Nowak, N-O-W-A-K, and Scheinin, S-C-H-E-I-N-I-N. And the first link that will appear will be the Consolidated Draft Statute, another draft statute for a World Court of Human Rights. So due to political oppression, challenges facing other international tribunals, as we've seen especially recently, and other global priorities, the Kozma, Nowak, and Scheinin draft statute for a World Court of Human Rights has not progressed either in or out of the UN system. So, well, now I'd like to mention why the creation of a World Court of Human Rights is actually important to me personally and how I got involved, which will give you more an understanding of where we're at with the newest version of a World Court of Human Rights, the Lucknow Treaty. So to answer this question of why it's important to me personally, I would like to return to Gary Davis. I started working with Gary Davis back in 1992 as the chief attorney of World Service Authority, the human rights organization he founded in 1954. When Gary voluntarily gave up his US citizenship in favor of world citizenship in 1948, he became stateless. I prefer to call him world full rather than stateless, because with his renunciation of national citizenship, he gained an awareness and an appreciation of the one earth that we all share as humans. He also gained an awareness and appreciation of the existential threat to the planet and to humanity posed by the divide and conquer nation-state war system. And he was, of course, a part of that war system, having been a bomber pilot in World War II. As a stateless person, Gary's rights to freedom of travel, to residency, to freedom from arbitrary arrest and detention, to vote, to participate in government, and other rights were frequently violated by national governments. When you're stateless, your rights can easily be violated. If you don't have a national citizenship status, to give you some form of protection of your rights, at least nationally, then you might not be able to claim many of your rights. Gary understood how the lack of a national citizenship perpetuates violations of rights. Let me turn up my light a little bit so that hopefully this will be not so blurry. Okay. So Gary understood how the lack of national citizenship perpetuates rights violations, which he faced personally and which millions of refugees, stateless persons, and displaced persons face every day. Many people who are falling through the cracks in the nation state system contact the World Service Authority, the human rights organization where I still work. Throughout his entire career, or his entire life as a peace activist, Gary sought justice not only for himself, but also for everyone as human beings first and foremost, and for the earth. Even though Gary was not a lawyer, he was one of the best legal advocates that I know. He took his human rights mission to court at both the national and world levels. Gary petitioned the U.S. Supreme Court about his rights as a world citizen. At the petition for rehearing, the court affirmed his right to advocate for world citizenship and world government, but the court also reiterated the national government's power to restrict his right to freedom of travel and other rights. At the global level, Gary filed a case before the International Court of Justice against Ronald Reagan and Mikhail Gorbachev as war criminals, pointing nuclear weapons at everyone. In this ICJ petition, Gary claimed that he was a subject of international law, just as the justices who sit on the ICJ court are subjects of international law. Gary, as a world citizen, was a state in and of himself. At least that's what he claimed. However, the ICJ refused to hear the case on jurisdictional grounds that an individual is not a state and that the court only hears cases of member states of the United Nations. In 2010, with the International Criminal Court as another potential venue for seeking global justice, Gary decided that he would take this nuclear weapons case before the ICC. This time, the petition would be against the 9 nuclear weapons heads of state who are putting humanity and Earth in danger. Gary argued that if there is such a thing as a crime against humanity, then humanity itself must be a legal entity, and humanity requires legal protection. If humanity is the plaintiff, then humanity can't lose the case. In his petition to the court, Gary established that the nation-state system is violating our ultimate human right, the right to exist, because the nation-state perpetuates war. And of course, in a situation of nuclear weaponry, that puts us in a situation of omnicide, potential total global destruction. So Gary said, law must be consistent with our human status. And what kind of law is that? Well, that's world law. Well, the court registrar at the International Criminal Court never acknowledged the petition that was registered, even though we received by post the registered return receipt from the court. The court did not want to answer this petition. If the court determined that nuclear weapons are legal, then the court would be negating their judicial requirement to adjudicate cases that are crimes against humanity. If they determined that nuclear weapons are illegal, the court would negate the ultimate sovereignty of the nation state to which the court is beholden for its existence. Anyway, nuclear weapon states would ignore such a ruling. Although Gary had written a draft statute for the World Court of Human Rights, as I mentioned, back in 1974, it was after the jurisdictional rejection by the International Court of Justice and the silence from the International Criminal Court that he decided, if no existing court will affirm the right of humanity to exist without the perpetual threats of war and nuclear annihilation, then we must create a court that affirms the rights of the people of the world. He was eager to relaunch a campaign to establish a World Court of Human Rights. Well, so not only was Gary concerned about the global threat of the war system, but he was also concerned about the violations of rights faced by the many individuals and groups who contact World Service Authority every week for human rights information and advocacy. On a day-to-day basis, individuals around the world call, email, and mail in requests for human rights assistance to World Service Authority. And here are just a few quick examples of some of those kinds of cases and assistance that we are working on. We've petitioned the African Commission on Human and People's Rights on behalf of two groups of Ogoni refugees, one group who is in Benin, displaced from their homeland in Nigeria, another group who's in Nigeria but displaced from their homeland within Nigeria because of oil drilling that has made their land unlivable. And we're still waiting to hear back from the commission. We've given them additional information as they've asked for. We've provided many thousands, hundreds of thousands, actually close to 5 million documents to individuals all around the world, many of them refugees, stateless persons, people who don't have access to any kind of document, or people who just want to support the idea of that we're all world citizens, that we all have fundamental human rights that should be respected. And for example, there's, as I mentioned before, the stateless Rohingya refugees who fled to Bangladesh and other countries as their villages were being burned to the ground by Myanmar government forces. This is one example of a group of individuals who find the documentation that we provide and the legal backup that we give very useful. We've drafted many amicus curiae briefs on behalf of refugees facing political, social, ethnic, or other social group or other persecution. A recent example is a Ugandan man who fled to the United States to save his life because of the severe harm he faced as a gay man in Uganda. Well, these violations of rights of individuals and groups frequently go unresolved at the national or regional level. And because human rights are inclusive and nation states are exclusive, that is, nation states exclude those who are outside of their man-made borders, nation states can't really effectively and independently affirm the global rule of law. Without law beyond the nation state and without judicial redress for rights violations beyond the nation state, universal respect for and observance of human and environmental rights will never be achieved. Gary Davis asserted that peace is not just the absence of war, but rather the presence of law. For him and the many people falling through the cracks in the system of sovereign states, individual rights take a backseat to national interests and national security. According to Gary, respect for the global rule of law and universal rights would be the key to world justice and eventually world peace. So in 2013, before Gary died, he called upon his fellow Vermonter, Mark Oettinger, to take up the mantle of designing a new draft statute for a World Court of Human Rights. And I launched the coalition to support the creation of a World Court of Human Rights. And I just want to quickly read from this email, and I don't know if you can see the actual size of the print, but this was an email sent to me just a couple of years ago from Benjamin Friends, who was the last living prosecutor of Nuremberg. And he says, "Dear David, I appreciate your letter asking for my brief comments regarding the creation of a World Court of Human Rights. My views are similar to those you cite from my friend, Judge Tom Bergenthal. As the last surviving Nuremberg war crimes prosecutor, of course, it would be desirable to have a World Court of Human Rights. Most of my life, I've campaigned for law, not war. I'm now in my 102nd year, and I have worked with many of those who sought a world government. The closest we have come to the desired goal has been the new International Criminal Court in The Hague." And then he goes on and complains about how executive orders imposing crippling penalties on the ICC and other things, and even investigating Americans for their work to promote the rule of law is problematic. And so those who dream of a world court should join me and many others in screaming against these latest outrageous attempts to subvert the rule of law. You may quote me. Best wishes to all, Benjamin Ferenz. So we have been building this coalition now for several years. We do have periodic webinars where we invite guests to come and speak to us about their actions in support of human rights or international law. And we appreciate everyone who might want to join our coalition to support us and to give us input on the draft statute, to review and look at, help us to put the two draft statutes perhaps together. And Mark will tell you more about his current activities to do this. So I just want to say once again, thank you so much. And I will, as Mark starts, I'll put some of the links in the chat that I mentioned, but I would now like us to hear from Mark Oettinger, who can tell us more about the Lucknow draft statute. Thank you.
Thank you, David. Thank you for your presentation. It's very interesting and it puts everyone here who's not on topic to be on board, just to be having nice discussion later. So please, Mark, be our guest.
Thank you, and good morning, everyone. And thank you, Melina. Thank you to the movement for making this seminar possible. I'm going to screen share a PowerPoint and go through it sort of a page at a time. Feel free to interrupt with any questions through the chat. So I'm an attorney, trial attorney
Sorry,
mostly in.
Mark. I'm so sorry. We are
Yeah.
seeing your computer, your mails. We are not seeing the presentation now.
Okay. Let me stop the share and let me try and let's see. Let's try that again. And actually, let's see. Chat participation. How about now? Are you seeing the PowerPoint? There it is.
Yes, now we're
All
seeing the
right.
PowerPoint.
And let me see if I can remember how to make it. David, you had a thought about making it full screen?
Yes, it was in view
In view.
You and
Yep.
then slideshow.
View and slideshow.
and
All
then
right.
slideshow.
Now I
Perfect.
think we're ready, right?
Yeah, thank you.
All right, so thank you. So as I was beginning to say, I'm a trial lawyer in Burlington, Vermont, in the northeast part of the United States. I happen to I lived back in 2013, about 3 miles away from Gary Davis's house. Gary had, as David mentioned, been a advocate, a zealot for a World Court of Human Rights and many more things regarding world government during his 91, I believe, year lifespan. And and so I got to know him because he committed what I might consider a bit of international political theater at one point, and making a point about immigration, which is a little bit beyond the scope of today's conversation. But when the court had Gary Davis in front of it, it felt that he deserved and needed representation. And so they called me, knowing that I do international cross-border type law. And that's how I got to know him back in, I think it was 2000. So during the period from 2000 to 2013, he and I worked together, sort of informally. And toward the end of his life, he asked if I would basically take up his cause. And I promised him that I would take up that portion of it relating to a World Court of Human Rights, which I would describe as the third leg of a three-legged stool, the other two legs being the International Court of Justice, a UN body, and the International Criminal Court, not a UN body, but each with different types of supranational jurisdiction. As David has mentioned, the International Court of Justice is basically a body that resolves disputes between and among nation states. And the International Criminal Court is fundamentally a body that tries world leaders for war crimes, crimes against humanity, that sort of thing, and then purports to act in terms of punishing the despots, let's call them that, for their actions. Um, but again, its jurisdiction is practically limited to criminal jurisdiction and punishment. So the International Court of Human Rights is different. And what we would propose to do basically is to create a World Court of Human Rights that would adjudicate, to begin with, selected human rights cases. Now, I say that to introduce sort of to remind us all of the certiorari process of the United States Supreme Court. They get bombarded with something on the order of 10,000 petitions per year. The European Court of Human Rights purports to deal with all of the petitions that it gets. The US Supreme Court, it's just a different judicial structure, selects usually about 75 cases to deal with in a given year. And it selects those cases in a way to basically try and assess, and we're going to talk about how a World Court of Human Rights would make the decision to take cases or not to take cases. And it's based on essentially the jurisprudential gravity of the matter at stake. If you have this body that is going to select, let's say, fewer than 100 cases to adjudicate per year, it's going to want to select those cases that are the most impactful from a jurisprudential standpoint. And we're going to see how we propose to do that. So typically it would address cases brought by classes of individuals. It could address cases brought by individuals, but oftentimes class actions, think, the people that live in Gaza, think the people that live in Ukraine. We're talking about situations where you have a very large number of individuals whose human rights are being violated or arguably being violated in a manner that is consistent across the class. We're talking about real-time situations, not the prosecution of despots for actions long gone by, not the dispute between and among nation states, but rather, the plight of millions and millions of individuals that find themselves in human rights catastrophes. I don't know what the current data numbers are, but the last I heard, there's something like 65 million people in the world who are either refugees or internally displaced. We're talking about mitigating the suffering and the hardship of those kinds of people and bringing benefits, bringing legal decisions in cases involving millions and millions of individuals where there's an actual hope that in real time the suffering can be brought to an end. Not punishment for suffering that occurred many years ago, but rather addressing real-time human rights crises. So that's sort of the model for the case. And then, of course, there's the issue of standing. For those of you who are legal scholars or whatever, if somebody purports to essentially represent or a large group of individuals, that would be deemed to have standing before the court. We'll talk about that. How would the World Court select its cases? As I said, it would be screened through a certiorari U.S. Supreme Court-like process. We talked about the fact that the U.S. Supreme Court has 10,000 cases per year or so that are brought before it. It selects a handful that are the most impactful. And we will talk about Article 21 that talks about how the court is going to be instructed to assess which hypothetical 75 cases from among the thousands and thousands of applicants should be taken into consideration. So cases accepted by the World Court of Human Rights would be decided in accordance with this growing body of international human rights law, which would include global, regional, and nation-state human rights statutes and treaties. David mentioned that back when the Universal Declaration of Human Rights was passed by the United Nations in December 10th of 1948, which is still International Human Rights Day, that it was not a treaty or a statute. It was not a document that countries signed on to specifically, but it did pass the General Assembly of the United Nations when it was sitting in Paris in 1948. And from that, related statutes and treaties have been developed, and we're going to talk some of those. So we have basically treaties, we have related case law. David mentioned that there's a European Court of Human Rights, there's an Inter-American Commission of Human Rights, there is a Pan-African organization. As David mentioned, there is no regional court of human rights in Asia, which represents 60% of the world's population, arguably 80 or 90% of the world's current human rights violations. And as such, there's sort of a dual mission of the World Court of Human Rights, which is to create an appellate body over this regional, if you want to call them intermediate appellate courts, and to also flesh out the intermediate structure by creating or helping to support the creation of a regional human rights court in Asia. And we will talk about Article 20 of the proposed statute. So the goal would be that the World Court of Human Rights would advance the development of human rights jurisprudence, in other words, the case law. It would promote awareness of human rights law and norms. We'll talk about how public international law works, because we'll talk extensively today about enforcement, because there's, for those countries that would be part of the treaty that creates the World Court of Human Rights, the international human rights law would be essentially become part of that country's domestic law. And to the extent that the World Court of Human Rights would issue decisions on that basis if the decision acts upon one of the member states, one of the states that is nation states that is signed on to the treaty. That decision of the World Court of Human Rights would be tantamount to a decision of the domestic courts in that nation and enforceable as such. That said, for those countries that are not members of the treaty that creates a World Court of Human Rights, you might say, what benefit would there be? Is there any enforceability? And the reality is that as the treaty process becomes more and more co-ate, we're going to talk about the history in a minute, obviously the more member nation states, the broader the enforceability of a decision of a World Court of Human Rights would be, and it is a stepwise process. Anytime you have a international body, there has to be a critical number, a minimum number of nation states signing on to the treaty before it is deemed to be in effect. And then over time, if we look at, especially since 1948, since the creation of the Universal Declaration of Human Rights, more and more countries have joined the handful, I think there are 9 now, of United Nations incubated human rights treaties, those having to deal with the 2 that David mentioned that go back to 1969, that involving civil and political rights, that involving social, cultural, and economic rights. But then there's international treaties that are almost universally adopted worldwide about women's rights, children's rights, rights of indigenous people, and treaties that prohibit race discrimination. So that awareness is a really critical component of the evolution of public international law. Some of the human rights organizations, such as Human Rights Watch or Amnesty International, talk about naming and shaming, and the fact of, that to the extent that we have ubiquitous information at this point, everybody has, this communication device in their pocket. If there's going to be a human rights violation in some far-flung part of the world, you can be pretty much sure that there will be videos of the events in real time on tonight's evening news, because there is this ubiquitous source of information. And that supports the idea of worldwide awareness of an initiative of this sort. So to the extent that there is the understandable and valid criticism that, to what extent would the decisions of a World Court of Human Rights be enforceable worldwide? The answer is that A, for the member states, it's domestic law, and for those that are not member states, it's part of the naming and shaming process, and worldwide awareness is critical to that. With the awareness will come respect, and we hope and we believe compliance. And that is a sort of a sequence of events in terms of the adoption of public international law that we've seen not just in the context of human rights, but in all of the other many contexts in which public international law has become a growing thing over the last century or so. So a little bit just what we were just talking about in terms of enforcement. One point that is worth making here on this slide is that the goal of the World Court of Human Rights is not to supplement the jurisdiction of the International Court of Justice, not to supplant, rather, not to replace it, of the ICJ or the ICC, but rather to be a separate freestanding supra, above the national level court that has a different mission, a different responsibility, but quite frankly, a responsibility that, if carried out successfully, holds the promise of alleviating the human rights suffering of millions and millions of people in real time. It's not just looking back. It's really affecting, preventing deaths, preventing suffering on a global scale. So just a couple of little details about the World Court of Human Rights remedies. It's not intended for criminal jurisdiction. That's the purview of the International Criminal Court. As currently envisioned, and this is something that has been discussed and criticized and commented on, it does not adjudicate civil damages. It basically indicates, under public international law, here's what the law says about the current situation in Gaza, in Ukraine, in Myanmar. And here's what the countries involved say in creating the human rights violation, in bearing the burden of, let's say, the displaced individuals that are now in a different country. It essentially, the World Court of Human Rights would essentially create case law regarding what are the respective duties of the nation states in the context of a large-scale class action human rights violation. David has pointed out that the model that we're talking about today is one model. There's another one that exists. But what we are looking to do is to create a World Court of Human Rights that is not a body of the United Nations. So in that respect, very different than the International Criminal Court. I'm sorry, different than the International Court of Justice, more like the International Criminal Court. But so why are we working with the United Nations at this point? And the reality is because that is where the incubation of treaties occurs. And so just to be clear, our hope is to incubate the World Court of Human Rights at the United Nations, but then to have it be a freestanding organization, so it is not subject to the various sort of idiosyncrasies of the United Nations structure, such as veto power of the five the major member nations. And so this is our model. Now, when I say this is our model, it's really the model of the world chief justices. When I was asked by Gary Davis to go assist in the creation of this modern age draft of a statute for a World Court of Human Rights, he sent me or asked me to go to Lucknow, India, where the world chief justices meet annually. They have, I think this is probably close to their 30th year of meeting. They meet in Lucknow, which is the capital city of Uttar Pradesh. Uttar Pradesh is the largest state of the 20 states in India. It is a state which by itself has about 250 million people. So it's up in the northeast corner or near the northeast corner of India. And I went there in 2013, 2014, and 2015. The first year to try and confirm what Gary told me, which is the chief justices were keen on this initiative, and they were. The second was to then spend a year working with a designated committee in the early days of video conferencing to produce the statute that we're talking about. And then in 2015, I went back to report essentially what we had done. You should know that the World Chief Justices, after the 2014 conference, unanimously approved the statute. And one of the dynamics is we think that the statute is very complete and very well thought through and a very effective one, taking nothing away from the Kuzma, Nowak, and Sheinin draft. And we don't have a huge amount of pride of authorship, but what the United Nations needs is a starting point. Essentially, it's like having a motion before a body at a publicly warned meeting. You have a starting point. The motion can be amended, and similarly, the draft statute that we're talking about can be modified, can be amended. But since the Chief Justices approved it in 2014, what we've been doing is collecting comments, collecting objections to the extent that they exist. We believe that the document is holding up very well under global scrutiny. And getting back to what Ben Ferencz said, and Ben was talking about Tom Bergenthal, famous law professor from Washington, D.C. He literally has written the books that some of us have read regarding public international law and the treaty process. He said there's no question that the initiative is very valuable. When he saw the draft statute, he said that the statute was very well done. What he said before I left in 2013 and subsequently before he passed away was that his concern is the world ready, which is one of those big things. Now, we believe, a coalition around the World Court of Human Rights, that the world is ready, and that's why we're committed to doing this. We, by the way, as I said, I'm a private sector attorney. I chair the International Law Committee of my state bar association. I'm a dual citizen. I'm also a world citizen. I carry a world passport. But I believe that this is the right thing to do. And it's something that I have done lo these many years. It's now more than 10, 11, 12 years, has been essentially on a pro bono basis. So let's take a look. This sort of illustrates, this is a little bit of a dated map, but this illustrates, I think it's Human Rights Watch, their assessment of the degree of human rights problems around the world. And so you can see this irony that there's a huge amount of human rights issues in Asia where there is no regional court. Now you might say, well, it's kind of a chicken and egg issue. It's easy to be, liberal, I suppose, when you live in a country that does not massively violate human rights, such as the United States, Canada, and so on and so forth. It may be, or in Western Europe. Africa, of course, is also an interesting area. They have a human rights regional court. But so this just gives you a little bit of a visual illustration of what David was talking about. So if we go back, how far back does a World Court of Human Rights, the concept come up? And what I'd like to do is go back to about the turn of the 20th century, so 125 years ago, which is, I consider, the modern era of human rights and public international law. It's not surprising, I suppose, that a lot of this, 1920, right after the end of the First World War, we have a Permanent Court of International Justice, sort of the precursor to the International Court of Justice, created. Try and put together the mess that was created by the First World War. And there were all these commitments that we, never again kind of thing. Well, I was just reading last night in anticipation today of the Treaty of Versailles that essentially solved in a sense the First World War. And but some people criticized that it was too sort of punitive of the losing side. And so it created a certain amount of hostility that ended up leading 25 years later or so to the Second World War. And of course, in 1945, the United Nations was created. In 1946, sort of the follow-on to the Permanent Court of International Justice, specifically the International Court of Justice, was created. And so we have a war and a response, and a war and a response. Here's David's, before the Universal Declaration of Human Rights was even approved, Australia had brought up this idea that, gee, we should have an International Court of Human Rights. That was eventually, as David said, did not come to pass. The year later, the Universal Declaration of Human Rights was approved. You'll note that it took 20 more years until the first major international treaty was adopted pursuant to the Universal Declaration of Human Rights. And since that time, I would say, and both the civil and political rights and the social, economic, and cultural rights compacts were essentially at the same time, and other human rights treaties followed. And so what I would say is that the rate of the extensiveness of the network, I sometimes call it a spider web, of treaties, which are basically, if there's a line between two countries, that's a bilateral treaty. Many of these treaties have, for example, the Civil and Political Treaty. The last time I checked, it had almost full universal adoption around the world. I think 165, 170 countries. Now, that's a little bit of a simplistic analysis for those of you who are public international law specialists, because there are special parts of the Civil and Political Rights Covenant that nation states can opt into, or out of, and so you can be partially in the Civil and Political Rights Covenant. One of the things that was envisioned there was that nation states could allow themselves to be essentially called to task or sued in the International Court of Justice if they were willing to do that. And a very small percentage of them have been. So this is part of why historically the ICJ has been limited to nation-state disagreements, as opposed to nation states being called to task about human rights violations. Another illustration about why a World Court of Human Rights is so necessary. And we just a little bit of sort of visual break here. Permanent Court of Arbitration, the League of Nations at the end of the First World War. You can see the extent of these meetings. This is the, this is The Hague. This building has a long, interesting history, but it is now where the International Court of Justice sits, and it also has a International Public Law Library and All of this arises out of the horrors of war. Gary Davis was fond of saying that if there are no nation state boundaries, there would be no war. And he and I spent many evenings debating the question of a world government. And I told him that at my age, I don't think I will live long enough to see it. I agree with Tom Bergenthal. I agree with Ben Ferencz that that is a desire, clearly a desirable outcome. It may take longer, but I think that during my lifetime, we can have a World Court of Human Rights. And so that's what we're pursuing at this point. This is a room that many of you are familiar with, the General Assembly. Here is the United Nations ambassador to the U.S. ambassador to the United Nations, Eleanor Roosevelt, wife of the then President of the United States, with the Universal Declaration adopted on December 10, 1948. Just a very small point. When Gary Davis was in Paris at the time of the adoption of the Universal Declaration of Human Rights, he actually disrupted the proceeding. He and a bunch of French intellectuals saying things that are actually recorded on newsreels and printed in Time magazine about the nation states that you, the people in the United Nations, represent, divide us. And we need something that basically brings us together. And so the Soviet Union at that point was threatening to use its veto power to reject the adoption of the Universal Declaration of Rights. But the day after the disruption by Gary Davis and his intellectual colleagues like André Gide and Albert Camus and people like that, the Soviet Union, for whatever internally, was convinced not to veto, and it instead abstained. And so in some respects, Gary Davis gets credit for the passage of the Universal Declaration of Human Rights, at least at the time that it took place. This is, just a quick commentary about the International Criminal Court. This is, for those of you who are history buffs, Adolf Eichmann, who was one of the, horrible perpetrators in the Second World War of the Nazi atrocities. This is what the ICC does. It basically brings to trial, sometimes in absentia, dictators and tries to hold them accountable for genocide, war crimes, and crimes against humanity. It is a punishment court. It is, and again, I do not mean to demean the value and the work of the ICC, but the World Court of Human Rights would address current problems and would arguably mitigate the suffering of millions and millions of people rather than focusing on punishment of individual dictators. So this goes back to sort of our project, 2013. 2014 was the drafting of the statute. Since that time, David and I have traveled to places like the Canadian Bar Association in Ottawa to present to them, the American Bar Association in Washington, D.C. We have, in the run-up to getting into the United Nations, we have talked with their former general counsel. We are working with the curator of the Nobel Peace Prize laureates, and I have as one of my objectives, David and I have just been given access passes to the United Nations, and we are going to begin the process of meeting with nation-state delegations for the purpose of trying to get a discussion of the World Court of Human Rights statute on the agenda of the UN. I would like to basically make common cause with the peace laureates to advocate for this. And so that's sort of where that stands. We have a website, worldcourtofhumanrights.net. I have a feeling this picture may no longer be actually on the website, but I commend the website to you. It's got a lot of good resources, including, for those of you who want to do public international law research or get some good links, historical resources, I commend it to you. I don't have the time today to spend a significant amount of time on the statute, but the little blue book that David held up is has the actual statute itself. The red articles are articles that I have broken out. Let's take a look at some of those. Substantive law to be applied, human rights conventions, custom, principles of human rights law, decisions, writings. Those of you that know the statute of the International Court of Justice will see some similarities. The World Court of Human Rights is limited to human rights issues, and it is designed to accept class action cases under traditional class action principles, for those of you familiar with them. Here's the selection of cases that we talked about. Is it within the subject matter jurisdiction of the court? Has the petitioner exhausted all their other national and regional remedies? You can't just go to the World Court of Human Rights. I mean, I suppose you could. Your chances of getting heard would be better in the minds of the justices, I believe, if you had previously gone to your nation state courts, or if the nation state that you come from is intrinsically, it would be futile, that's the way the case law reads, to try and exhaust your nation state remedies, because there really aren't any. You could think about, off the top of my head, places like maybe North Korea. Would there be, if there were to be a human rights petition filed by North Koreans, would there be a necessity in the minds of the justices of the World Court of Human Rights to exhaust remedies? I don't know enough about what remedies there may exist in North Korea, but we know there's no regional court. In a case like that, you may get direct access. The court also would assess qualitatively how serious the allegations are, quantitatively how many people are involved in this suppression of human rights, how strong the evidence is, what degree of enforceability. Does the law within the regional courts and other nation states need harmonization? And so this is just a little bit of a glimpse into a certiorari system in the context of human rights. It would have contentious jurisdiction. It would have advisory jurisdiction under appropriate circumstances. But notice H rather at the bottom of both of these. There's this question about what's a political question as opposed to a legal question. This is a fraught area. For those of you that are public international law specialists, you know what I'm talking about. And as a general proposition, the court would be required by the statute to steer away from political questions, which would be considered non-justiciable under U.S. jurisprudence, and to limit itself to true legal questions. Class actions we've talked about, which would be the way. Standing and party status. What if a group of individuals that is being repressed or suppressed, or whose rights are being violated, says, how would Gazans as a group get standing before the court? Would they have the ability to represent themselves? Well, they might be represented by somebody like Human Rights Watch or Amnesty International. That's called public interest standing. And there's also an ombudsman's office that is contemplated, which essentially is an independent office within the World Court of Human Rights that would assist the court in identifying independently, without being part of the court or subject to the court's jurisdiction. It would essentially be a starting point for individuals or groups that wanted to access the court but didn't have the wherewithal to do so. And in appropriate cases, the ombudsman's office could actually arrange for representation if the case were something that the court deemed appropriate for consideration. We talked about exhaustion of remedies, that this court would be a court of final jurisdiction, not a court of initial or original jurisdiction. And that's just a question of judicial efficiency. There are cases, sadly, there are so many cases all around the world that come to mind. This list changes over time. Some of them stay the same. The issue of climate, whether or not, the current climate situation is in fact, allowing it to happen and allowing places like, Nauru to essentially potentially disappear underneath the Pacific Ocean, whether that amounts to a violation of human rights. Who knows? It's certainly within the purview of the court. Our efforts are not so much to try and prejudge how the World Court of Human Rights might adjudicate the Ukrainian case or climate change or women's rights in Nigeria or anything like that. So who knows how the court would judge such cases? We're trying to create. I'm a judicial systems specialist. I'm trying to create a vessel that would be appropriate and efficient for the job that is not currently being performed by the supranational courts that we do have. So David mentioned the coalition. We are hot on the question of which nation states would be interested in talking with us. One of my colleagues down in New York City has said, as a starting point, when you come down to pick up your pass before the end of the year, you should meet with the Austrian delegation. Again, I'll meet with anybody who is interested in hearing from us at the United Nations. Again, we want to be free of control by the United Nations, but we want the process of adopting the treaty, fashioning the treaty to be to take place there, because that's where we have the greatest chance of actually getting the process meaningfully started and hopefully completed. So that's a quick synopsis of what the design is, what the idea is, what we have been doing, deep history, more recent history, and where we hope to go in the near future. I'll stop there and give it back to Melina. Thank you.
Thank you, Mark. That was a very wholesome graphic picture of the situation and how to avoid it. Now it's time for the Q&A section. I know there's a couple of messages on the chat. I think that some of them have been answered, but I will ask if someone here wants to ask a question to either Mark or either David to raise their hands so I can see them. Or it doesn't have to be a question, it's just a comment maybe. Well, I'm not seeing anyone, so I'm going to take something from the chat that I think that it, sorry, Alenka, please.
Hi. I have a question regarding making the regional court made only from stakeholders where none of the governmental officials are appointing the judges on such a court, so the citizens can effectively rule also over the government. Because right now, if we just see Europe, for example, always is like this, that the government is appointing the judges and the courts, and they are basically political, not independent, which is very hard to prove, but we can see that through the to the decisions which are made. So we are interested in, for example, in Slovenia, to make such a court that can be created from stakeholders, from the people actually, and how to make the state that this would be accepted, like, I don't know, arbitration or something like this, where just the facts are presented and then this decision is made.
So maybe I can start on that. The statute, and I'm going to try and pull it up for future questions here, but the statute of the World Court of Human Rights has a provision in it, I think it may be Article 5, that governs the selection of the 15 justices that would be essentially in charge of the court. It's broken. The way the World Chief Justice model works is that the 15 justices would be appointed roughly in proportion to population from 5 different regions of the world. And there would be a committee of the group of nation states comprised from that part of the world, let's say the Americas. There'll be a group of individuals appointed who would then decide which individuals would be nominated to sit as justices on the World Court of Human Rights. There are a set of standards in terms of experience, high ethical requirements, and so on and so forth. And then there are provisions in the statute of the World Court of Human Rights that would allow for the dismissal of judges in the event that they demonstrate corruption or lack of diligence. I'm paraphrasing at this point, but I totally agree with you that making sure that the justices of the World Court of Human Rights are independent and not simply puppets of the governments that may want to protect themselves is a critical function. And I will I will attempt to pull up the statute and so I can illustrate that section. But that's a great question. I hope that begins to answer it.
Yes, this is about the World Court that you were saying about. How about creating a regional court in one of the states?
Well, that's a good question. Because of the fact that the completion of the regional courts by adding an Asian court, because of the fact that that was an issue that came up, I think, after the Lucknow conferences, we have not studied. That's a good question. We have not studied the question of how would the justices of the Asian Regional Human Rights Court be determined. To the extent that it would be a model that would be parallel to the World Court of Human Rights, again, the emphasis would be on independence, and there would be, it would not simply be possible for, the nation states that could potentially be the respondents in a case claiming human rights violations. We certainly would not want their predetermined folks that are going to be biased in favor of the nation state. It needs to be independent. And so there is an attempt both to have independence on the incoming side, and then also to ensure that if somebody gets through that system but proves not to be independent, that they could eventually, with a supermajority of the court, be excused from the court and be replaced. So I thank you for flagging the selection of the regional human courts, folks. I will take a look at how that's done at the European Court, at the African Court, in the Inter-American Court, and basically put that research with that element, because that's going to be something we will confront. So great question. Thank you.
Thank you.
I would just like to follow up really quickly with that before we get to Alan's question. And that is to say that I know that the proponents of the consolidated draft statute made the determination that in their draft statute, the independence of the regional systems would remain independent, and that their decisions would not necessarily be appealable to a World Court of Human Rights. I think under the Lucknow statute, you can tell me, Mark, or not, but that we would consider that potentially a possibility for further review of a human rights matter at the World Court of Human Rights, even if there had been a decision at a regional level. But it is certainly a disputable viewpoint that we need to come to a higher coherence in discussion about that.
Good point. And so if I can just attempt once more to share. So I was wrong. It's not Article 5, it's Article 4. But as I said, it's not just Article 4 that talks about, the geographic distribution of the justices will be from the following regional groups. But there are other sections here in the statute that deal then with the conditions of service, dismissal of justices that I've talked about, and so on. But, one of the things you bring up, which is that, this statute that we created in 2014, that was unanimously approved by the World Chief Justices, we know it's not perfect. We know that there are things that should be done maybe that haven't been addressed. I'm not sure that there's anything in the statute that has been perceived to be blatantly inadvisable or wrong. But it would be irresponsible of us as a design team to now try and modify what the Chief Justices have approved. But we fully understand that when we get this before the court, and also sort of side by side it with Kozma, Nowak, and Sheinin proposal, that picking and choosing between the two to create the ideal model, we fully recognize that this is going to go through an evolutionary process. So this is a starting point. As I analogize, it's sort of a motion made in a meeting. And we know that it will be modified, it will be amended, it will be improved upon through the process. And the independence of the judges is absolutely critical to the success of the court. I agree.
Thank you. I know that Alan sent some insightful and very interesting questions to the chat, so I'm very, very eager to listen to what you have to ask.
Hello, thank you, Melina. I'm Alan Ware, Program Director for the World Federalist Movement Institute for Global Policy. And thanks a lot for Melina convening this and for David and Mark for the really substantive introductions to this. It's really great and fantastic we can have this conversation. If you don't mind, I've got 4 questions. A couple are pretty short and 2 might be a bit more substantive. The first one is Australia and Switzerland produce draft statutes, as you mentioned. Is the Lucknow draft similar or drawn heavily from the Australian and Switzerland drafts? And are Australia and Switzerland still champions for the campaign? That's one question. Another, in the Lucknow draft, it has English as the language, but this doesn't seem to be universal. The ICC has the 4 UN languages with English and French as the operating language. The International Court of Justice has French and English as the languages. So wouldn't it be better to have French and English as operating languages and the 6 UN languages as the full languages able to be used in the court? Then question 2. Question 3 was on jurisdiction. And I agree with the universal application of customary law because customary law is that which is universally applicable. But I find it difficult to see how you can have jurisdiction over a treaty when only one of the parties to the dispute is a party to the treaty, because treaties are only binding to those states that are parties to them. So I'm interested in your explanation of that. And the final one is on advisory opinions. It seems to me that the way you've got the approach or the process for advisory opinion is similar to contentious cases. But in general, that's not the way this is dealt with in international tribunals. So, for example, with the International Court of Justice, the advisory opinion is on a matter of law that is requested by a suitable body like the UN General Assembly or ECOSOC. To me, it would seem that the advisory opinion process here could be enacted, for example, through the Human Rights Council, through the UN General Assembly, ECOSOC, or through other UN bodies. So it generally is an advisory opinion on the application of law, more generally, rather than a contentious case. So I'm sort of interested in that as well. Thank you.
All right, so let me see if I think I heard 4 questions there. So the first question having to do with the Australian and Swiss versions, are they still active? Are they still advocating? The answer is the Australian version, I think, was sort of which was back actually in 1947, even before the Universal Declaration was passed. We found one of our presenters when we were in Ottawa brought the actual documents from 1947 archive demonstrating how far back that effort had occurred. I don't think that anyone is advocating that still, but I'd be happy to be proven wrong. With respect to the Kozma, Nowak, and Sheinin document, absolutely, they're very involved. And I fully expect that our statute, let's call it the Chief Justice statute, and the Swiss statute, if we want to call it that, will be sort of side-by-sided as the UN begins the process of picking and choosing the best from each to create, in our vision, a final statute. The language piece. I think the fact that we've been working in English is probably a reflection of the fact that those of us that, David and I are predominantly English speakers, and that the Chief Justice Conference occurring in India as it does is always occurs in the English language. I agree with you that, once the statute becomes adopted, once the court, and it currently requires 10 nation states to join in before the treaty becomes active. By the way, we did not start with the Australian and Swiss models. We started sort of side-by-siding the ICJ statute and the ICC statute because essentially we were creating another supranational court. And even though its subject matter jurisdiction is limited to human rights, it shares a lot of sort of procedural and structural characteristics of the ICJ and the ICC. So we use those 2 documents as a starting point. Once we have a statute and once we have 10 or more nation states signed on so that the work of the court can truly begin, I think it needs to be translated into, if not, 6 languages, then, maybe 160 languages. I would also hope that as we progress, AI will make that an easier lift, because certainly, the statute itself is important in terms of creating awareness and respect for and enforceability of the work of the World Court of Human Rights, and therefore people have to be able to read it. Customary law, non-binding, the non-binding piece. If you look at the ICC, they actually try war criminals sometimes in absentia. And that sort of goes to this question of, you can either have cases before a World Court of Human Rights where both parties are signatories to the treaty, which makes enforcement relatively easy. And it makes the decisions of the World Court of Human Rights tantamount to the decisions of the domestic courts of the member countries. Even in the absence of a membership, our statute, and this is what the Chief Justices felt was appropriate, allows for the invitation of any countries that are not signed on to the treaty. Somebody files a petition. Let's say that the citizens of Gaza file a petition against the nation state of Israel. Let's assume that Palestine, and I know that's another sort of specialty issue given the status of Palestine within the United Nations. But let's assume Palestine is deemed to be a member state, and Israel is not. Does that mean that the case cannot or should not go forward? I think that's kind of at the crux of your question. And the answer there would be that under the statute as currently envisioned, the case could go forward, and Israel would be given a full opportunity to respond, to submit evidence, to participate. Should they choose not to do so, I think the sentiment of the Chief Justices would be that would not, their view is that should not deprive the court of the ability to look at the case. It would be important to take all views, to see the problems from all sides, and that's why the non-member nation state would be invited to participate. But if they chose not to, the court still would have an obligation to attempt to find facts accurately and apply those facts as understood to the public international law of human rights as it exists. So as far as your fourth point, I think, had to do with the advisory process. You probably know a lot more about the advisory process as opposed to the contentious jurisdiction, if you will, than I do. One of the things that I know that the Chief Justices would prefer not to see is that the advisory process of a World Court of Human Rights would refer back to the United Nations and its processes. They felt that the processes of the World Court of Human Rights should be independent from the United Nations for the reasons I indicated, because of the veto power and the potential politicization of the efforts that occur at the United Nations. Again, a little bit beyond the scope of my knowledge base, but again, the contentious and advisory jurisdiction, if you look at the language and you look at the way in which our statute is designed, they do derive from the similar parallel situation in the ICJ statute. So I know there was a lot, but that's what I.
And Alan did ask another question, which was regarding the International Law Commission of the Sixth Committee of the UN. So just to say that, as Mark had mentioned earlier, we just received UN passes, and we expect to be going to the UN, maybe Mark in December, maybe in January. And one of the groups that we, of course, intend to approach is the ILC and the Sixth Committee, as well as the Third Committee that deals with human rights. I guess the important point is to say, even though we've been working on this process for many years now, in a sense, we're just at the beginning. And this is why we need everyone's help, everyone's input and interactions to make the process for creating this court actually take into account all of your concerns and considerations to make it a stronger presentation in the end when we're trying to get the world's support for this.
And let me just touch on one more just anecdote, which is that in the early 1990s, there was an effort to create a landmine treaty. That treaty was adopted and has resulted in the prohibition of, or partial, the intended prohibition against landmines, and then the efforts to remove landmines from former areas of combat in the interest of preventing kids and civilians and from essentially being victimized by landmines that are left behind after a war. In a very similar manner, that effort was led by an individual named Jody Williams. The treaty was incubated in the United Nations system. It became a treaty that is essentially implemented outside the United Nations, and so it is that model that in some ways we are hoping to follow. In other words, incubate in the United Nations, but then not be sort of subject to some of the foibles and idiosyncrasies that attend doing business within the UN. That may or may not be a well-informed position, but that's the position of the world chief justices. And so in any case, we want the point was mentioned in an earlier question about the independence of the judges. We want to be independent of any influence. We also want to be independent of political influences insofar as they may be found at the United Nations. I mean, my father was a D2 in the UN. I have great respect for the organization, but I think that everybody on this call is aware that, has the United Nations lived into its charter completely? And the answer to that may be no. There are nation states that have very clear and powerful positions in the organization that they don't want to give up. I do think that the veto power does create constraints and limitations and gives rise to rational criticism of the body. But I think, if the United Nations is an absolutely indispensable international supranational tool, it may not be perfect, but there are other people that are attempting to work, forward for helping the work of the United Nations to evolve and to improve and so on and so forth. But that's the model that the world chief justices have. And since we can't really approach the United Nations saying, well, this is sort of like what the chief justices approved, except a bunch of people have tinkered with it later. We have the list of proposed tinkers. We want to go before the United Nations with the world chief justices and the Nobel Peace Laureates. And I should point out that the person who led the efforts for the Nobel Peace Prize, led the efforts for the Landmine Treaty, won the Nobel Peace Prize in 1995. It was Jody Williams. And so, if I envision myself being at the United Nations, making this presentation to the 6th Committee or the 3rd Committee or the General Assembly, in theory, I'd like to have the key members of the Chief Justices who were involved in working on this on one side of me, and perhaps one or more members of the Nobel Peace Laureate group supporting it. Again, we don't have any pride of authorship. We realize that what we're talking about is such a massive historic change that it needs input from all interested parties in order to be the best statute that it can possibly be. We just think that in distinction to what Ben Ferencz may have cautioned us about and Tom Bergenthal may have cautioned us about, we believe that the time is now. And so that's why we're so focused on this.
Thank you, Mark. I mean, I think that the last sentence you said is summarize everything. The time is now. So thank you. And talking about time, we are running out of time of this meeting. I know
just want to make
yes.
one final comment.
Sorry,
Sorry to interrupt.
Yes.
And that's really just to say thank you so much to the World Federalist Movement, to their American counterpart, Citizens for Global Solutions, for all their support to me as well as to Mark and to the World Court of Human Rights Coalition to be able to present this information in different venues, not just today, but previously and in the future. Thank you again so much for this opportunity.
Same for me. Thank you.
Thank you. I really thank you both, David, Mark. I think that it was very interesting, all the conversation, all the presentation, the debate that was after the presentations. I think that it's an important topic that we should discuss, and we should discuss these different points of views and the different thinking that we create on debating things and talking about. And so I think that it's very important to have this kind of meetings. I want to say thank you to everyone to came to this meeting. I know that it's late on the year, so everyone is with a lot of things right now. So thank you for taking the time. And this meeting is being recorded, so when we have the recording, we will send it to you. So if you know someone who is interested about these topics, I want to listen to it, it can. So thank you everyone, and have a nice day.
Thank you.
Thank you.